Your Lordship, Your Lordship, kindly leave be granted to file the wakalatnama in the department.
Yes, please.
Grateful, Your Lordship.
Yes. The Lordship is the file for inclusion.
Origin side.
That's left side.
The other bench heard it.
Yes.
They are wondering whether we'll keep it. We have a judgment and other matters also on of that bench. So we'll keep it on that date.
It was only for filing of notes.
Written notes.
So we can subject to what your Lordship.
All right, very well. We'll take on record the notes. We'll
Lord,
take on record the notes. And
not only one
Yes.
predicament, but I'm representing respondent number 2, 3, and 4. Lord, the complainants. Lord, I'll kindly grant me 1 week's time only to file my
so
notes.
then
It's
take
ready.
the written notes of
It's
that date.
ready,
We'll,
Lord.
we'll try to. We'll not try to. We'll keep that bench on a particular date and we'll take
Then
it.
we come file it there, my lord. Yes.
Better,
Yes.
better, better.
We'll do that.
Yes.
As requested.
You are for S1 number.
2, 3, and 4, Lord, I am the complainant.
Although the other parties are ready with the written notes of arguments, comma, an accommodation is sought for filing of written notes of arguments by the 2 to
2, 3, and 4.
2 to 4. Who's the next para? Accordingly, let the matter be placed before the bench. Heard it in part.
Lordship.
Grateful, man. Grateful.
Lord, 1 and 2 same on.
Same. 1 and 2 same one.
Same.
3 to 10 action call kora. 3 to 10 similar predicament, we'll just record an order that it will be placed before the regular bench and we'll try to আলাদা করে সবকটাই অর্ডার করে হ্যাঁ অর্ডার কন্টেন্টটা সেম হবে কন্টেন্টটা বলে দিচ্ছি since the matter has been heard in part by a bench of different composition comma let the matter be placed before the said bench এইটা আলাদা করে সবকটা আলাদা করে অর্ডার দেখে up to 10 this order. So try to put that bench as quickly as possible. Yes.
Item number 9 and
Till 10 will item 5.
10, yes. Noted. Noted. Presence is noted.
No, not what would happen? Because that beloved
What
item
would happen, God knows.
My lord, we are also for
If both the judges are alive in this court, everything else remaining constant in the language of science, then that bench
item
will sit.
number 5 is concerned.
No, in advance we'll publish in the list when that bench is sitting next. Because we have so many part-heard matters, we have to sit together the other way.
But the lordship will at all because that number 5 only my lord heard Mr. Dasgupta. I couldn't be present on that date. Other side has not been heard.
We'll decide while sitting with Justice Bhattacharya, we'll decide that. I mean, we'll do whatever we have to.
Grateful, my lord.
Thank you.
Lordship, item number 9 and 10, I appear for the appellants. I just wanted to bring this to your knowledge, your Lordships, that this was an assigned matter. And this was assigned.
Once the matter is heard in part by a particular bench,
Yes, yes.
that bench has to take up the matter. Assigned, non-assigned, from different high court, from different bench, it is the same. Yes. Same logic applies, I suppose.
And your lordship, this matter is also getting settled and before a different bench it was.
Get it settled before it appears before the regular bench.
Lordship, the matter is
The other-
appearing for the executing court on 24th of August. Kindly keep
No,
this up.
record an order. No, record. You are for the
I'm for the review applicant.
learned counsel for the review applicant submits that the matter is getting settled between the parties. Full stop. However, comma, since the application has been filed for review of an order passed by a different bench, comma, let the same be listed before the said bench as and when the same reassembles. This is an 11. 12 টা আলাদা করে কল করো। Has to go before the regular bench. Since the matter arises out of a review application of an order of a bench of different composition, comma, let the same be placed, then let the matter be placed before the same bench as and when the same reassembles. পরেরগুলো বার করে রাখো। Pass over in the first. Pass over. Pass over. Pass over. Pass. Pass over. Pass over. Pass over.
Your Lordship, 2 weeks adjournment for.
Why 2 weeks adjournment? 17.
Yes, Lordship.
Item 17.
Yes, Lordship.
APO. What is the APT number?
Original, sir, Lordship.
What is the number of the matter?
So, I will check.
If you have to check the number, then we are not confident that you are mentioning the right number. Passed over. Passed over in the first. Same. 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 Passed over in the first one. Passed over. Yes. Same.
Millard, I appear for the Apple, Millard, the respondent.
Same. Pass over. Just decision. Pass over.
The 32, I am for the appellant. My lord, there's another order, my lord, another appeal from the same order, my lord, that has just been released by the other division bench,
All right.
but that has not been assigned to you.
Can you give us the number?
Yes, my lord.
I'm liking
Number take to note করে
Yeah. My lord, I'm writing it down and giving.
তাহলে একটা
395 of 2023.
you are for the appellant in this?
Yes,
Mr. Learned counsel for the appellant submits that the present appeal is that a connected appeal
from the same order.
ought to be listed along with the present matter. So accordingly, let the said appeal bearing number such and such উনি যেটা লিখে দেবেন be listed along with the present appeal.
But that's not yet to be assigned, my lord. That one.
Comma subject to being
That's
accordingly থেকে কেটে দিন তার আগেটা আচ্ছা আচ্ছা পুরো থেকে then counsel for the appellant submits that a different connected appeal is at present appearing before another bench. Full stop. It is further submitted that in all probability, comma, the said matter shall be released.
has been released.
Has been released.
Oh,
That's fine.
submits that the said matter has been released and the parties have sought assignment before assignment from the Honorable the Chief
Chief
Judge. Full stop. Next para. In the event the said matter is assigned to this bench, comma, let the same bearing such and such number be listed along with the present appeal on August 21, 2026.
Great for it. 34 আমরা আছি না 34 না
That's good. Pass over.
well 34 my lord, I am for the respondent order.
They have not yet started argument.
No, my lord.
We are passing over in the first call.
Very well, my lord.
Pass over.
Initial matter of the respondent. It's not been heard yet. Lordship, that one direction in December was given. Now the government has changed and the ASG. Lordship, one more direction just seeking that they should file their affidavit.
There was a direction for filing affidavit.
Lordship. 24th December 2025, Lordship.
Unless they pray for an extension, Mr. Banerjee, how can we?
Everybody, after even restoration, every day they are praying for. Most of the days they are not there.
We would take a chance in the first call and let us see. We are passing it over in the first
Second
call.
call. Okay, Lordship.
The second call will pass over. Same. Pass over. Same. Same. Pass. Same.
Millard, 45 Millard, I appear for the respondents. Millard, I
Yes.
have been not been served with a copy of the appeal.
I appear
Even
for
Mr.
the
Alim
appeal.
is there. If they can serve a copy on me.
With him.
No.
No,
I'm-
he's
Yes, Lord. We'll
Learned counsel for the respondents submits that no copy of the papers connected with the appeal have been served on him. Accordingly, the appellants shall serve copies of the memorandum of the appeal as well as other connected application, comma, if any, comma, on the learned advocate for the respondents. Full stop. The matter be listed next on
Next Wednesday, Millard will come back. Subject to Millard's.
August 19, 2022. আচ্ছা previous matter যেটা বললাম সেটা 21 বললাম সেটা August 19 হ্যাঁ
That matter.
previous matter will be August 19. Please inform Mr. Roy
Yes,
Choudhury. Please inform Mr. Roy
Yes,
Choudhury.
ma'am. He's leading me. I'll inform.
Oh, you are also there.
August 19.
Millard, just Millard, one more indulgence. Millard, items number, Millard,
No, we have a second call.
23. Millard, he is only
No,
there.
Millard, I'm opposing Millard. They have to start. That Millard, I'm opposing. That he has to start. He cannot Millard fly away.
His optics are very selective.
Millard, may I
That-
say, Millard, just one thing?
No.
In the second call, we'll decide. Yes. Let us
Okay.
put it in a proper manner. Second call. করুন।
Okay.
13. হ্যাঁ আপনি কি সেকেন্ড কল হচ্ছে একটু ঘুরে দেখুন কি করছি We find from the order dated July 22, 2026 that none appeared for either of the parties on the said date. We find from the order dated July 22, 2026 that none appeared for either of the parties on that date. Next para, even today, comma, on the second call, comma, none appears for the parties. Full stop. As a last chance to the appellant to argue the matter, the same is adjourned till August 19, 2026. Registration মনে হচ্ছে ফাইনাল registration টাইম ফাইনাল ওনাকে বুঝিয়ে দাও কখন কল করতে হয় কাগজপত্র তো এটাতে একই same order, exactly same order as the previous one. Order sheet দাও, order sheet দাও। এটা নিয়ে নাও। একই আরেকটা দিন আসেনি না এটা কনসিস্টেন্টলি আসছে না ডিসমিস ডিফল্ট করে দিচ্ছি order. We find that on two previous occasions, that is on September 24, 2025 and December 24, 2025, comma, the matter was adjourned on the prayer of the appellants. Next para, thereafter, comma, on May 13, 2026, comma, May 20, 2026 and July 2022, comma, July 22, comma, 2026, comma, none appeared for either of the parties at the time of call. Full stop. It transpires that the appellants are no longer interested to proceed with the appeal. Full stop. Accordingly, APO 514 of 2017, along with IA number GA1 of 2017, bracketed old number GA994 of 2017, are dismissed for default without any order as to cause. Interim order, if any, stands vacated. Next. Call on the next.
এটা একবার একদিন টাইম হয়েছে 20th মে টাইম হয়েছিল 22nd জুলাই আরেকটা
হ্যাঁ order record করে দিই পরেরটা একটু লিখ পেরিয়ে On May 13, 2026, comma, when the matter was called on for hearing, as well as on July 22, 2026, comma, none had appeared for either of the parties at the time of call. Full stop. On May 20, 2026, the matter was adjourned on the prayer of the appellants. Full stop. Next para. Even today, comma, in the second call, comma, none appears for either of the parties when the matter is called on for hearing. Full stop. As a last chance to the appellants to argue the matter, the same is adjourned for the day. Next. এইগুলো পরে এসে কেউ নাম দিলে ঢোকাবেন কেন আমরা বলছি
Lordship has
17? Yes.
Nobody is appearing in this matter for a long time. The order 7 in rule 11 was filed by the defendant allowed. This is a defamation suit on the law point. Kindly fix any date, convene to your lordship after 2 weeks.
The last occasion only it was
Yes.
adjourned on your prayer.
This is the affidavit. My affidavit of service was not ready on that day. That's why. Now this is the affidavit of service.
We'll give them a last chance, Mr. Pallad.
Madam, after 2 weeks. I will not be here for 2 weeks.
When should you keep it? Tell us.
After 2 weeks.
So after 2 weeks means today we are on
26th.
12th of August.
My
26th.
My lord, deeply obliged.
The affidavit of service filed today be kept on record. They have been served.
Yes.
Yes. It transpires therefrom that the respondent has been duly served. However, comma, at the time of call, none appears for the respondent, comma, although the appellant is represented by counsel. So next para, as a last chance to the respondent to contest the matter, the same is adjourned till August 26, 2026. It is made clear that in the event the respondent remains unrepresented on the returnable date, comma, the matter will be taken up ex parte in the absence of the respondent.
Deeply obliged.
You can, if you like, Mr. Praladka, communicate this order also. We are not.
Yes, yes, I will
not
definitely.
directing you.
No, I will. I want them to be present because this is a defamation.
That will be easier for all of us.
Even if you
Because
also allow my
again,
appeal again,
recall
the
application.
same thing.
Exactly.
I will do it.
মজার ব্যাপার না ডিভিশন অফ প্লেন আমরা অ্যাপেলের চাইলে হলে রিজেকশন হলে ডিভিশন অ্যালাউ হলে অ্যাপিল এগুলো সবই অ্যাপিল বলে এটা
The appellants have been consistently unrepresented before us, comma, as it transpires from the orders dated December 24, 2025, comma, May 13, 2026, as well as May 20, 2026. You are appealing for the appellant.
I am, this is a request, Mr. Deepnath Roy Chaudhary is appearing. He is stuck in
Yes, sir.
traffic. Deepnath Roy Chaudhary is appearing for the appellants. So he is stuck in traffic. It will be
Collected
moved
it.
over for some time.
This is the second call.
I understand your lordship.
On the prayer of the appellants, comma, the matter is adjourned for the day.
Much obliged. Thank you.
Someone's name has to be recorded because you have recorded a prayer, your name will be recorded. Or whoever's name you choose, not his name. How can it be? On his ground, you are asking for it.
I'll ask for the clerk to give some junior's name. His junior's name.
Do it immediately. You have to record a name now. We'll record Mr. Banerjee's name then. Your junior. Yes. So we'll keep him for ransom. Yes. Unless the other junior's name is given within 5 minutes, his name is recorded. এখন নাম রেকর্ড করুন, নাম দিলে রেকর্ড করুন, না হলে শীর্ষ ব্যানার্জি রেকর্ড করুন, 5 মিনিট দেখে নেবেন, না হলে শীর্ষ ব্যানার্জি রেকর্ড করুন। নেক্সট, ইয়েস, দেখি অর্ডার শিট ক্লিয়ার মুড। এত লোক অপেক্ষা করছে আর এই মাথাগুলো ঝুলিয়ে রেখেছে। বলবি we find from the order sheet that on December 24, 2025 and May 13, 2026, comma, none had appeared for the parties at the time of call. Push up event today, comma, on the second call, none appears for the parties. Push up next para. Accordingly, APO 57 of 2021 is dismissed for default without any authorized cost. Interim order, if any, stands executed. Next. Dismissed for default.
Lordship, I'm appearing for the appellants. On the last occasion, Lordships were pleased to record the settlement, talks of settlement that was going on. Now, Lordship, Lordship, may I indicate there was a letter issued by the respondent personally to the appellant between the parties, Lordship, on 19th of May 2026. I can hand up copies. Now, all that was required to be done by my client was to express the consent. That consent has been expressed. I do not know why my learned friend is submitting that it has not.
No, but that is not a binding contract. You can.
I understand, Lordship. I do not know
Hearing
why
both of you don't
my
say that-
instructions.
No, then you argue the matter. You cannot force any party to agree.
Lordship, then Lordship will record that the.
You argue the matter.
Very well, Lordship. Mr. Dutt is leading me. I can
Start the
commence.
matter. You are
I
sufficiently confident to start it. And to end the matter also if he does not come.
no, Lordship, they were very well.
Yes.
Perhaps my papers are not here.
Record a short order. Learned counsel for the appellants submits that the respondents had directly written to the appellants for settlement of the matter out of court. What was left was only for the appellants to express their consent to such offer. Next para. However, learned counsel appearing for you are for respondent numbers 1 and 2. Respondent number 1 and 2 submits on instruction that the said respondents are not agreeable to settle the matter out of court. Accordingly, we request learned counsel for the appellants to commence arguments.
Now, Lordship, there is an application filed by the respondent. Lordship will.
Yes, move that application first. What is
that? My learned friend is not pressing for the application.
Supposed to be supposed to. Where is the application? Application to the application first volume to the. What is the appeal against?
Lordship, the appeal is, there are two appeals, Lordship, arising out of one order in respect to two applications. My application originally was, the one was the dismissal of the suit as under Order 7, Rule 11.
Rejection of the plaint.
Yes, my return of the plaint, my lord.
Return or rejection?
Rejection of the plaint, Lord.
Rejection, right.
Lordship, the other ground, Lordship, the other application was filed by the respondent, plaintiff, on the ground that the clause, there were in fact earlier suits filed before the Barashat court, which was subsequently transferred to the commercial court. Now, the stand taken by the plaintiffs before this honorable court was that those suits may be transferred before this honorable court. Now, that application, along with a prayer for clause 13, leave. Now, that Lordship has been allowed. What appears, Lordship will kindly take the impugned order.
Your suit was for? What was
Lordship,
it?
my suit, Lordship, this is arising out of, may I, Lordship, kindly give a brief of the relationship between the parties. Lordship, there was.
In which the plaint has been rejected.
Lordship, that suit is in respect to alleging fraud of an agreement for transfer of shares, payment of the consideration.
So you seek for a cancellation of the deed.
Lordship, my learned friend's client seeks for cancellation of the contract.
Your plaint has been rejected.
Lordship, not my plaint, the respondent's plaint, Lordship.
Your plaint has been rejected. And you are challenging
my application, Lordship, has been my applicable is.
You are for the appellant here.
Yes, my lord. My application, there were two applications, one filed by the defendant and one filed by the plaintiff. Lordship, I am
their application clause 13 was allowed, you are challenging that.
Yes, my lord.
And your 711, their plaint was rejected, they are challenging that.
Lordship, no. Lordship, my application was disallowed. I am challenging
711 was rejected. The application was rejected.
Yes,
711 application.
Yes, my lord. That is why I am agree.
And clause 13, their clause 13 was filed by whom? You.
Lordship, by the plaintiff.
That was allowed.
Yes, my lord.
You are challenging both. You are
yes,
the appellant. So you are the appellant in both the applications.
Both the
applications. So what was the suit for?
Lordship, may I? Lordship will allow my senior to
answer. Yes.
Oh, yes. Your brainchild.
They sufficiently held the fort for you.
Oh, settlement.
You wield your scepter from the
I was putting it down because I thought item number 4 I'll be able to hold your lordship for the whole day. 4 gone, 6 gone, 9
failed our expectations.
The settlement of
No, but nothing could be done. That's a part matter before a defense.
That is what struck me yesterday. But I thought that probably your lordship will take it up.
What can you say? What did you say?
Let's not start.
No, we'll fix that bench also. We'll sit sometime. We have to. I've had a talk with the Honorable Chief Justice. There are certain, I mean, give us some time, we'll reassemble.
No, we are not on that.
On particular days of the week, we'll sit.
That's
Yes.
but a little reluctant to start the appeal to Timothy. I'll give your lordship the back.
The rusty in the matter.
The thing is, I got prepared long back. Thereafter, I was not expecting this matter to be taken up today. I'll give you the background. There was an agreement entered into between my client and the plaintiffs. The plaintiffs approached me at a time when they were facing SARFAESI proceedings and other bank proceedings. Now, there was an agreement by virtue of which they wanted to set up a hospital in Salt Lake. Now, they had taken loan from the bank. After taking loan from the bank, they had approached somebody who said that we'll take care of the bank loans if you transfer the property. He wriggled out, then he came to me, and thereafter I helped him out.
You are a financier.
I am not a financer per se, but thing is, I helped. I don't carry on business of money lending to start with. Now, it so happened, after this agreement had happened, there was certain transfer of shares that took place, but the central purpose of all this is that building at Salt Lake, which is supposed to come to me. It's a leasehold interest of the plaintiffs.
What was your stake in this grant of loan?
That I had purchased this loan, nothing. I had just taken over their responsibility. I have not taken the loan. I was just
no, they took the loan. You
I was trying to bail them out by paying off the bank.
But and you did not have any consideration for that.
No, this building would entire will come to me, will shift to me. That was done by way of mode of shareholding. Now, after we paid a percentage of the funds, it so transpired that there was a breach according to us. 2 suits were filed. One suit filed by me for specific performance of that agreement, which suit was filed before the court at Barasat.
You filed the suit?
I filed the suit on the court at Barasat, alleging there is a breach. There is another suit filed by my learned friend, also in the court of Barasat, where they say that there is breach and they also ask for. So both parties basically want to perform, but with the terms. Now, these 2 suits were
paid. They didn't want the cancellation of that agreement?
No, that cancellation they have want now. So these 2 suits,
what was their suit for? Damages for breach?
Let me. There was a claim for
money. Your notes.
The first plaint is at page 140.
No, before going to the plaint, just give us a backdrop.
They want money, we want specific performance. So basically, ad idem that this is there. Agreement, but the only quantum difference is as to the money.
So both rely on that agreement?
Both rely on that agreement. There is no dispute. And they both say that entire subject matter cause of action arose within the jurisdiction of Barasat Court.
All right.
Now, thereafter, there comes a third suit, which is filed over Calcutta High Court. In the Calcutta High Court, they filed a suit saying that you are not willing to perform. There is a question, you are fraudulently doing this. We are asking for, you are transferring the shares to further third parties, which we have transferred. We ask cancellation of the shares. And for cancellation comes delivery upon cancellation of the contract. Now, in this suit, the entire plaint in the Barasat suit has been set up. Paragraph wise paragraph. There is only one additional paragraph that a lawyer has lodged a complaint, criminal complaint for breach of peace, the breach of trust, which is also filed in Salt Lake. But the suit has been filed over here on the premise that part of the cause of action has arisen.
So ideally, you should have asked for return of plaint.
Ideally, we asked for return of plaint, but your lordship knows, the process which we follow in this original site, we file Order 7, Rule 11, because there is a divergence of view whether Order 7, Rule 10 applies to the original site, applies to the High Court or not.
Order 7, Rule 10 applies to the High Court?
Whether. Because that last order for which says that these will not apply, but there are judgments which say that it does. But the process...
Why shouldn't it apply?
Well, I don't know. There's CPC.
Original side rules override. If there is a contrary rule, there is no contrary rule to order 7.
There's a provision in
So,
it. Well, we do CPC. I'll show you that order, Millard. The last order. Probably.
So the caption, there is a similar provision. Order 15.
Right. Clause
15. The clause 15 applicability is different.
Millard, yes, Millard, that is there. Millard, it would be order
49.
Order
49.
49.
Order 49 rule 2. Report apply.
Rule 3.
I don't know. Good question. All right. So precisely, nothing in this schedule shall be deemed to limit or otherwise affect any
Rule
rules.
3. The following rule shall not apply to any chartered high court in the exercise of the ordinary civil jurisdiction.
Oh, acha, Anand.
Mr. Mukherjee just told me that there is a judgment of Justice Deepak Sen Millard where the transfer provisions of clause 13 has been applied to return the plane. And
You're thinking that
obviously there is some
Exactly.
devices there has
clause 13, you can invoke clause 13.
so Millard,
If not anything,
let's take it,
151.
Millard, at the highest, even if I could have satisfied the court would have returned the plane or rejected the plane with liberty to file because
By that logic, rule 11 is also not applicable. B and C. B and C.
B and
B
C.
and C. A and D are applicable. But it would be a disproportionate punishment for them to reject the application. They can the next day file in another court.
But Millard, rejection of plaint on this ground does not prevent them from filing another suit.
Then we can mold the relief also if necessary. So you sought a rejection primarily on the ground of territoriality. Territorial jurisdiction.
Yes, and that nothing territorial. It's a suit for land to start.
So that why was that rejected? That order 7
But it was rejected on the ground that the suit is a suit disputing the transfer of shareholding.
So what arose within the jurisdiction of this court?
Nothing.
Nothing. The office of any of the companies? No, something is there.
That
Oh,
will that is
you are
not the
Vidhan-
cause of
you are
action.
the defendant. Yes, they are Vidhannagar, you are Vidhannagar. Property in Vidhannagar. What is on-time securities and all?
But those are the shareholders who are claiming through or under me. So they don't have a
No.
parent cause of action is that. I
The
just
company
need,
itself gave the loan. They
yes,
entered
yes,
with the
yes, absolutely. Which has a registered office into that.
all right, whatever. So that is your challenge. And what about the other challenge? Other appeal?
Millard, while dismissing the suit, Millard, the court
If
felt
this is returned, it's consequential. If it is returned, then it
if
should
it is
not.
later, Millard, those suits are already lying there, Millard, and
Rather, this suit should go
there.
that court.
That is, I just need to place the two planes, Millard.
Yes, can we start with the impugned order? If not, because we'll get to know what we have to look for actually. You can start in your own way, Mr. That if you want to place the planes first, you're welcome to do
Does one way mean that I can come back?
No.
Okay.
You cannot lose your own way. We'll guide you
That's
along the
why
path.
I
It may be a garden path, but we'll guide you along that.
okay. Millard, give me the order to the 585. Millard, your lordship is looking at APO 84 of 2020.
So that the difficulty before us is we have several heads in the appellate side. Each of the heads is scrambling for attention. And we have separated the days between different heads in the appellate
Millard,
side. For original side, we have these 2 days.
No,
We don't
Millard,
want to lose the advantage of having these 2. If you fail your chance here, then I mean, we don't know when we'll be able to take up. And with the things which are, I mean, the reshuffling and shuffling, I have to sit on a one of the days of the week with Justice Bhattacharya.
I'll it's only thing that
Sits.
once if I'm ready, I get that flow. Otherwise, I have to keep on
So
searching.
you'll have your flow. in the motion.
Kindly, Miller, take the impugned
This is
order.
not a big matter. If we
No,
can get us,
I just need to place the two plates.
Yes, yes.
Kindly take, your lordship has
Give the
APO.
volume numbers, Mr. Dutt, so that we can take out those volumes.
Yes,
The plates.
Miller, APO 84 tabar. Volume 5 thing.
APO 84, volume 5.
Yes.
That is one plate. And the other plate?
No, the planes are at page 1, take volume 2 and volume 5. Impugned order is in volume.
Impugned order, we have the memo, so we follow from.
Oh, very well.
Planes are in volume
volume 2, page 140 and at 181.
Volume 2 ta thale. APO 84 er volume 2 দুজন বছর। Yes.
তখন ভলিউম হবে 14018। থ্যাংক ইউ।
But in the cause of action paragraph also it stated Salt Lake. তো বারাসাত সুট বারাসাত না এটা তো হাইকোর্টের সুট না কোনটা আমি দেখি No, this is the Barasat suit. We
Same
want
here, in here also.
to show us the plaintiff of this
Okay, page 4 of volume 1. Page 58, Miller, paragraph
58, yes.
Yes.
So, part cause of action.
No, cannot be, Miller. If it is a suit for land, Miller, then part cause of action.
What part of cause of action they refer to? Look into that.
Miller, the only difference in cause of action is paragraph 60. As I told you, Lordship Miller, it's cut copy paste of the plaintiff except these 3 paragraphs.
What could be the their best paragraph in regard to this? 16.
60. That is according to the only paragraph. The commission of the fraudulent acts as pleaded in paragraph 41 hereby occurred at P15 Bentinck Street, Kolkata within the jurisdiction as major part of the cause of action has arisen within the jurisdiction of the Honorable Court. As part of the cause of having arisen outside the jurisdiction of the Honorable Court, this plaintiff plays a clause 12 has stated. Paragraph 41, your lordship sees.
Paragraph 41.
Yes.
Agreement intended to at Salt Lake, everything at Salt Lake.
Everything.
Registration office.
Everything. Even the property in respect to
Properties at Salt Lake.
Even the complaint.
Your offices are at
Yes, the complaint also says the commission of offence. The subject matter is the commission of commons fraud. That also says that the offence offered at
Complaint was referred to in the plaint.
Miller, at page 15. Miller. Paragraph.
Page.
Complaint are there?
The complaint was pleaded in the plaint, so that we can look into that.
Yes, Miller, just a minute.
241, 42.
Miller, after the fraud,
very well.
Miller, kindly see paragraph 42. The plaintiff has already lodged an FIR with the officer in charge, electronic complaint.
Annexure. So let us look at annexure.
58.
Up to
center. If the defendant number 1 has committed fraud through the defendant number 2, that also will be at the registered office of the company.
If the agreement enter into the transaction of fraud. Agreement was entered into at Lenin Sharoni, page 59.
Milord, that the plain doesn't say so. The plaintiff in the citizen will, if it is a suit for land, it will make no difference, as I say.
No,
No, Milord.
Registered at Salt Lake, maybe.
No, no.
But at page 59.
Milord, your lordship is going to the part of cause of action. If it is a suit for land, if the reliefs pertain to the property in question.
Yes.
Which is the subject matter of the previous two suits as well as this suit.
This suit, the relief is not on land.
It's for declaration of a delivery up and cancellation of the agreement.
Agreement. It's a contract.
Which includes that title to the land.
No, but that's a roundabout way of viewing it.
So, Milord, the primary relief. So, if your lordship looks at the primary relief, what he wants is, Milord, delivery up and cancellation and restoration. Now, Milord, these two agreements, once I show to your lordship, Milord, your lordship will find this is primarily for transfer of shares for handing over control of the land at Salt Lake. Delivery up and cancellation of this would mean direction or Milord trying to get hold of that property by
It will be a consequential relief, Mr. Dutt. The main relief is not on land, but on the agreement, on the contract to the party.
Yes, the contract is to transfer. Milord, let me place it in that sequence, Milord. Then.
If the contract was entered into at Lenin Sharoni,
Milord,
although for cancellation on the ground of fraud, the perpetration of fraud is the cause of action, maybe.
Yes, but that according to them, the fraud arose in Salt Lake because the complaint was lodged before the Salt Lake police station.
Yes, very good. After looking into this prayer, Mr. Dutt, we think we'll come back from the impugned order first. Because we want to see the logic of the learned single judge and then test it on the anvil of these.
Yes, yes, please.
Because then we'll know what to look for, basically.
Yes.
So apparently we're right, because complaint was at Salt Lake, property at Salt Lake, both all of your offices.
Show your lordship, Milord, the two previous planes, Milord, your lordship will clearly see. Milord, I'll just give an indication, Milord, since it's troubling your lordship, Milord. Kindly see after the delivery up and cancellation, what are the prayers?
But they're trying to avoid that by seeking a clause 13.
I beg your lordship.
They're seeking to avoid that.
Yes. If it is brought here by way of 13, then it says under one umbrella, so piecemeal trial. That's the reason why clause 13.
Maybe.
Will kindly see the consequential release that would.
We don't determine the jurisdiction, jurisdiction by consequential.
I'm not saying that, Milord.
You cannot do that.
I'm not asking your lordship to do that. What I'm trying to say is this, Milord. Delivery up and cancellation of a document by virtue of which a property is sought to be transferred, Milord, would be taking away the defendant's right to claim any right over the property.
So would it then be a suit for land?
Yes.
All right, we'll consider it. So let us come to the impugned order, please.
Yes, let's start with the impugned. Two applications, Milord. I need to place it. Can I place it, Milord?
Yes.
Two applications have been taken up analogous hearing as they concern the same parties. Defendant number 2 has applied for dismissal of CS 250 of 2015 by old GA such and such in CS such and such. The defendant number 2 has applied for dismissal of an application under clause 13 of the letters patent filed by the plaintiff in ALP by way of such and such. Learned senior advocate appearing for the defendant number 2 has submitted that the instant suit relates to there should be agreements, Millard.
Yeah.
Agreements dated May 16, 2012 and April 10, 2013 entered into between the plaintiffs and the defendant number one. The defendant number one instituted title suit number 192 of 2014 in the Court of the Learned Senior Division, Second Court, Barasat, seeking specific performance of the agreement of 10th April 2013. The plaintiff have instituted money suit number 101, which was before the Learned Senior Division, Second Court at Barasat. So two such suits in Barasat in respect of that agreement. The two suits had since been transferred to the commercial court. Learned Senior Advocate Defendant has submitted that the subject matter of the instant suit relates to an immovable property. He has referred to pleadings of money suit number 101. He has submitted that the plaintiffs could have sought the same relief as has been sought in the present suit in money suit. He has also pointed out that although the plaint of money suit number 10 of 2015 had contained a prayer for leave under Order 2, Rule 2 of the Civil Procedure Code, the plaintiffs did not obtain any such leave at the time of institution of the money suit number 101 of 2015. In fact, subsequent to the present application, the plaintiffs have applied in money suit number 101 of 2015 for leave under Order 2, Rule 2 of the Civil Procedure Code.
So Order 2, Rule 2 was also one of the grounds in your Order 7.
Yes.
That's why probably Order 7 will be.
Yes. And that was pending. They did not apply for Order 2, Rule 2.
Before institution of this suit, they had not obtained the leave.
No. Once we take out that application, simultaneously they go up. That is what is there. He contended that the plea taken in the application for grant of leave under Order 2, Rule 2 of the Civil Procedure Code in money 1 is specious. He is contended that in any event, the fact that the plaintiffs did not obtain Order 2, Rule 2 of the Civil Procedure is now established. In any event, money suit 101 is being prior to the institution of the instant suit and the plaintiffs not having obtained leave under Order 2, Rule 2 CPC, the present suit is not maintainable. That's the second ground. He is contended that the cause of action forming the basis of money suit 101 is also the basis of the present suit. Learned advocate appearing for the plaintiff has contended that the subject matter of the instant suit is different from the previous money suit. He is contended that the parties to the suits are different. He has contended that in money suit, the plaintiffs have claimed recovery of money from the defendants herein. In the present suit, the plaintiffs have claimed release with regard to the two agreements entered into between the parties. There they claim specific performance. Here they say that deliver up and cancel it and restitution. So it's continuation of the same cause of action. He contended in the money suit, the plaintiffs have claimed recovery of money from it. In the present suit, the plaintiffs have claimed release with regard to two agreements entered into between the parties. He submitted that the defendant number 3 is the assignee of the immovable property. The plaintiffs having faced difficulties with regard to the immovable property and financial accommodation enjoyed from the financial institution, plaintiffs had entered into an agreement with the defendant number 1 and 2, whereby and whereunder the defendant number 1 and 2 agreed to bail out the plaintiffs from such financial difficulties on certain considerations. Not only did the defendant 1 or 2 renegade on such permission, the defendants 1 and 2 arranged the affairs of the defendant number 3 in such a manner so as to wrest control of the defendant number 3 from out of the plaintiffs. The instant suit is in relation to management and control of the defendant number 3, which the defendant number 1 and 2 have wrongfully taken over by the plaintiffs. If this is so, Millard, then also, Millard, it's solid. And it's so advocate, but this wasn't the plaintiff's submission. Then it's also advocate appearing has replied on Millard these judgments. Appearing for the plaintiff has contended the defendant has deposited a sum of ₹3 crores which the court required the defendants to do as security. He submitted that since the causes of action in the two suits are different, the question of dismissal of the present suit being Order 2, Rule 2 does not arise. Then Millard, Olka Gupta and other judgments were cited. The code enumerates which is a civil suit can without trial, we may refer them. Millard, Lordship, I can skip these, Millard.
Please, then you can
Millard, come to page 10 of that judgment. In order for the provision of Order 2, Rule 2 of the Code of Civil Procedure to apply, there must be identity of causes of action between the parties and the subsequent suit. The causes of action for the previous suit must be established to have entitled the plaintiff to more than one relief, and that the plaintiff in the subsequent suit had omitted to sue for the relief in the previous suit. that the plaintiff was entitled to form out of the cause of action for the previous suit. In other words, whole of the claim has to be made. That is what, two suits must be between the same parties. This probably is not a rule of order 2, rule 2. It's the plaintiff's obligation to include all the cause of action.
There
If
are some-
subsequent cause of action arises, then Miller, that's
Some
different.
extra parties here.
Miller, as I told,
Shareholders.
the shareholders through are claiming through or under them. In the facts of the present case, the plaintiff has filed, this is the finding. In the facts of the present case, the plaintiffs have filed money suit number 101 of 2015 against 4 defendants. The defendant number 1 and 2 herein have described as defendant in money suit number 101, while defendant number 3 and 4 herein have been described as pro forma defendants therein. In the present suit, the plaintiffs have impleaded 37 defendants. The first 4 defendants of the present suit are party defendants in money suit number 1.
Shareholders were confirming parties to the agreement.
Yes. No.
In what? Why?
What because Miller, they say that after handing over the shares to you, you have also further transferred the shares to these 37 persons. So the act complained of Miller is the parent breach. That would be Miller cannot be the cause of action of the plaintiff until so long he is asking for specific performance of the agreement. The first 4 defendants of the present suit are party defendants in money suit number 101, with the defendant number 3 and 4 herein being the defendants here. The plaintiff in the instance, in the plaint of the instant suit, the plaintiffs have claimed that the defendant number 3 is an assignee of the land measuring on such a so lying at D25 Salt Lake, Kolkata. The plaintiffs have claimed that the plaintiff number 1, being a doctor, had been interested in setting up a hospital. The plaintiff number 1 had incorporated the defendant number 3 in order to fulfill such dream. The defendant number 3 had applied for and obtained credit facilities from the defendant number 5. As security by the defendant number 3 had mortgaged the Salt Lake property. In favor of the defendant number 5, the plaintiff have executed personal guarantees in favor of the defendant number 5, which is the bank. In the plaint of the instant suit, the plaintiffs have claimed that the authorized share capital of the defendant number 3 had been rupees 50 lakhs divided into 5 lakh equity shares of rupees 10 each. According to the plaintiffs, as on 29 June 2011, the plaintiff number 1 held 20,000 equity shares and the plaintiff number 2 had such and such equity shares held in the defendant number 3. The plaintiff have claimed in the plaint that of the instant suit, the plaintiff suffered financial crisis. The plaintiffs have entered into an agreement with the defendant number 4 on 4th June 2011 for the purpose of ensuring completion of the project of the defendant number 3. According to the plaintiff, the defendant number 4 has issued letters to the defendant number 5 promising payment. According to the plaintiff, the arrangement between the plaintiff and the defendant number 4 was that the plaintiff could transfer the entire shareholding of the plaintiff in the defendant number 3 for a consideration of 20 lakhs. Out of 20 crores. Out of the sum of rupees 20 crores, the defendant number 4 would pay 8 crores to the defendant number 5, rupees 50 lakhs to the plaintiffs to meet the sundry creditors of the defendant number 3. According to the plaintiff, the defendant number 4 failed to keep its commitments and made a partial payment to the defendant number 5. But I am not defendant number 4. In the plaint, the instant suit, the plaintiffs have claimed that in December 2011, this is where Miller, the cause of action, the plaintiffs were introduced to the defendant number 2. The defendant number 2 had expressed the intention to take over the project of the defendant number 3, which is the hospital. The plaintiffs and the defendant number 2 had entered into an agreement of 16 May 2012. According to the plaintiff, although the defendant number 1 and 2 were obliged to honor their commitments under the agreement dated 16 May 2012, they failed to do so. The plaintiffs had entered into subsequent agreement of 10th April 2013 by superseding the previous agreement to the extent set forth therein. The defendant number 1 had filed a suit for specific performance of the agreement dated 10th April 2013.
That April 10 agreement was also within this?
Yes, with the same party. It only modifies the consideration. Filed a suit for specific performance of the agreement of 10th April 2013. According to the plaintiff, the defendant number 1 and 2 had failed and neglected to pay the agreed consideration for the plaintiff. According to the plaintiff, the defendant numbers 1 and 2 did not comply with the agreement of 16 May 2012 and April 10, 2013. The plaintiff have instituted money suit number 101 of 2015.
This is for breach.
That is Millard? No, money. I want specific performance, he wants money. So basically what is happening is, I am saying that give me specific performance.
Oh, money in terms of the agreement.
Yes. Yes.
That's also virtually specific performance.
Yes.
Oh, not for breach.
No.
Not damage.
Breach is here.
Breach for the first time here.
Yes.
So that was for damage, not for damages.
Their claim was, Millard, for
you have to get the rights in the property and they have to get money. So both of you asked for implementation of the
and therefore these two suits were treated together.
All right.
And here, Millard, according to the, I'm sorry, Millard, the plaintiffs have alleged that the defendant number 1 and 2 had issued unallowed shares of the defendant, unallotted shares, sorry, Millard. The plaintiff, it should be unallotted.
Yes.
Unallotted shares of the defendant number 3 in favor of the defendant number 6 to 33. This is Millard, the breach. The plaintiff, money suit, the plaintiff have alleged that the defendant 1 or 2 have issued unallotted shares of the defendant number 3 in favor of 6 to 33 and have gained wrongful control over the defendant number 3. So even Millard, if delivery upon cancellation, declaration, management of defendant number 3 and defendant number 3 management means the hospital.
Of the immovable property.
Yes. Through such mechanism. Such issue and allotment had been made in a single day without any consideration. According to the plaintiffs, the defendant number 2 and the defendant numbers 5 to 32 have perpetrated fraud on the plaintiff and the defendant number 3. The plaintiffs have particularized the fraud so committed in the above subparagraphs of paragraph 41 of the plaintiff. According to the plaintiffs, the defendant number 5 to 32 are shell companies. It should be Shell Millard. Shell companies over which the defendant number 1 and 2 have absolute control. In the instant suit, the plaintiffs have sought release with regard to agreements dated 16th May 2012 and 10th April 2013, as also control and management of defendant number 3. It has been noted above, there are 3 suits between the parties. It has been noted above, there are 3 suits between the parties. The defendant number 1 and 2 have filed a suit for specific performance of the agreement. The plaintiff have filed a money suit. In order to consider the applicability of the provisions of Order 2, Rule 2 of the Code of Civil Procedure, so far as the present suit is concerned, the cause of action of money suit number 10 of 2015 have to be taken into consideration as the present suit has been filed by the plaintiff hearing. I could not understand, Millard, but in money suit 101 of 2015, although the plaintiff have claimed that the defendant number 1 and 2 had acted deceitfully in relation to the agreement between the parties in the money suit, which before the trial court, in relation to the parties, agreement between the parties, the plaintiff did not claim any relief with regard to the issue and allotment of shares of and in the defendant number.
In the previous suit also they had alleged deceit.
Yes. That is why, Millard, relief chain is immaterial.
Obviously, if they sought the relief, then
so, yes. Millard, deceit is also there. The defendant 1 or 2 have not brought any material on record to substantiate that the plaintiffs were aware of the issues and allotment of shares of the defendant number 3 at the time of filing of money suit number 1.
Yes. Either subclause 2 or 3, Order 2, Rule 2.
Yes.
Abundant claim or could have asked for did not.
Yes.
Very good.
But my lord, your lordship will notice, I'll come to that.
And let us complete this and
Yes. My lord, paragraph 17 I was placing.
yes.
As noted above, the three suits between parties, the defendant want to have filed specific performance of the agreement. The plaintiff have filed a money suit in order to consider
So
the
came to deceitfully last.
Yes,
in
my
money
lord,
suit.
I
You
just
can start
lost
from,
that line.
5 lines from the bottom in money suit.
In
number-
money suit 10, although the plaintiff have claimed referendum number 1 acted deceitfully in relation to the agreement, the plaintiff did not claim any relief with regard to the issue and allotment of the shares of the defendant number 3. The defendant number 1 and 2 have not brought any material on record to substantiate that the plaintiffs were aware of the issue of allotment of shares of and in the defendant number 3 at the time of filing of money suit number 101 of 2015. This is, my lord, with respect, not the test of order 2.
So the distinction is on the basis of the further transfers which you effected to the defendant was 5 to 32. That is constituted as a different cause of action.
Attempted to, and which is the subject
No,
matter
the court recognizes that as a separate cause,
cause of action. Because court says that you will have to show, if you want order 2, you will have to show that
This was available.
Yes, he had knowledge
Yes.
of that deceit.
The relief had to be available for them to abandon.
But the plaint I will present, my lord, it was available to them. But be that as it may, my lord, I had the better point which I would like to, my lord, that's going into the merits. The cause of action of the two suits are different. The plaintiffs have claimed release with regard to the issue and allotment of shares of and in the defendant number 3 which were absent in the earlier suit. That is, of course, my lord,
that is the
drafting that
the
has
condition of order 2.
Yes. In such circumstances, I am of the view that the present suit is not barred under order 2 root to them. In such circumstances, IAGA 2 is dismissed without any order as to costs. The plaintiffs have claimed that with regard to the two agreements in the present suit, the agreements on the basis of which the plaintiffs have sued the defendant relate to a company incorporated under the provisions of the Companies Act 56. It relates to shareholding of the defendant number 3. This suit therefore can be said to be commercial dispute in the meaning of the suit has been valued in excess of the specified value. Agreement question such suit have been transferred to the commercial division. In such circumstances, it would be appropriate to invoke the provisions of 15 and transfer it to the commercial division. And thereafter, my lord, the defendant number 2 has filed IAGA 2 in ALP seeking dismissal of the same. The plaintiffs have applied in ALP 4.
Territorial jurisdiction point you took in the order 7 rule 11.
Yes, my lord.
That has not been decided at all.
That's the point.
All right.
Paragraph 3, last paragraph.
Paragraph of the order.
Paragraph 3, page 2, paragraph 3.
Yes.
Well taken, my lord. The suit for
Relates to immovable property. No, only this much. Relates to
I have to only show that the release pertain to immovable property. And the plaint which we do, we only say it's a suit for land or relief pertaining to or touching immovable property. That point was not decided.
You specifically took this point because territoriality you have to take the objection.
My lord, I will order some
at the first possible opportunity. So
এটা তো ওনারা করছে তুমি জজ সাহেব যেটা জিজ্ঞেস করছে সেটা His registered office at Salt Lake, came forward as a replacement of Recon. After such negotiation, the plaintiff entered into an agreement on 16 May with Fana India Limited to transfer the entire shares lying in the name of the plaintiff in VMPL either to Fana Idea Projects Limited or to Mr. Vualka. This is the crux of the agreement. It is pertinent to mention that though the agreement was signed on 17th March 2012, the same was dated 16th May 2012. Your plaintiff state that the agreement dated 16 May 2012, as per the agreement 16 May, in the event of transfer of fully paid up share, that is 27085 shares of BMPL, standing in the name of the plaintiff in favor of Fana India Limited, Mr. Vualka or his company will immediately pay a sum of rupees 10.50 crores to the plaintiff, and for performance of the rest of the terms of the said agreement, which includes payment of bank dues and transfer of shares lying in Recon in favor of Fana India Limited through proper recourse of law, another sum of rupees 10 lakhs will be paid to the plaintiff in addition to the above. Mr. Vualka, without entering into the agreement, was supposed to make an upfront payment of rupees 1 crore some 1 crore to the plaintiff. The agreement dated 16 May states in brief, the parties to the agreement are the parties to the agreement agreed on the following terms. 1 crore to be paid by the plaintiff on signing of the agreement and taking action for cancelling the agreement. 10 crore to be paid to the plaintiff for creating bank loan, for repaying bank loan, repayment to Recon and balance to be retained by the plaintiff. 10.50 crore to be paid to the plaintiff on immediate transfer of the plaintiff's share to the funding. In pursuance to the said agreement dated 16 May 2012, the plaintiff duly performed and complied a substantial part of the agreement by transferring most of the shares, that is 26900 out of 70, in favor of Mr. Vualka. As has been directed by Mr. Vualka, it is pertinent to state that only the remaining portion of the shares of VMPL standing in the name of the plaintiff, that is 185 shares, was kept in the name of the plaintiff under the instruction of the defendant number 1, with the objective that the plaintiff will file a suit in their name against Recon to get the shares of VMPL standing in the name of Recon to be transferred to the defendant number 2. In particular, the following steps to be taken by the plaintiff as per the obligations under the agreement. On 15 May, plaintiff issued notice to Recon. 16 May, plaintiff transferred their shares in VMPL in order in favor of the defendant number 2 instead of the defendant number 1 under direction of the defendant number 2 as per the agreement. Plaintiff number 1 transferred so and so shares and the plaintiff number 2 transferred such and such shares held by her. Then Millard, on 17th May, as per the direction of the defendant number 2, your plaintiff duly filed a suit against Recon before the Honorable High Court at Calcutta for recovery of the shares standing in the name of Recon and the plaintiff number 2 claiming such and such. On 16th May, the defendant number 1 and 2 complied with the plaintiffs to call the board of directors meeting on 16th May itself, and the minutes prepared by the company secretary to the defendants, Mr. S.M. Gupta, the plaintiff, were instructed to sign and allot so and so shares and issued shares of VMPL authorized share capital of the defendant number 2. On the same day board meeting, 5 new directors were inducted as to the direction of the defendant number 2, Arun Kumar Vualka, defendant number 2 himself, and below the 4 directors. Then Millard,
So all these merged into the second agreement, 10th of April, 2013.
and performed. And they say it's been performed. Directors were inducted in the board of the company. Shares were being transferred.
No, rupees 50 lakh and all 3 crore.
Yes,
At
but
page
this.
191, the modalities of the new.
Oh, your lordship has gone to page 191. I'm sorry, Millard. That's why I was. Millard, I'll come to 191 then.
Yes.
Then 10th April. Oh, that was an
According to
indicator
them, you gave out to them that a new agreement will be entered into and you will pay 10.5.
Then Millard, 191 last paragraph, pertinent to state that prior to the entering into the new agreement of 10th April, the plaintiff at the demand of the issued a letter addressing to the bank to release the original documents, including title deed, possession certificate, etc., lying with the bank in favor of the defendant number 2 in the event he pays off the entire dues to the bank. This letter was written by the plaintiff to the said bank along with the bank resolution on the undertaking that the same will be very much essential for the defendant number 2 to deal with the bank property. Be it mentioned here that as to the instructions of the defendant, a writ petition was also filed. Then Miller this. However, till date, this is Miller, till date, the defendant paid rupees 50 lakhs only on 11th May and failed and neglected to pay the balance 3 crores, which has become due and payable since July 2013. And also 25 lakhs further remained due on the said account. সেটা পরের কথা.
Then the deception comes.
Yes. Your plaintiff state that Mr. Vualka deceived the plaintiffs by taking hold of VMPL company along with its assets. This is mirror what I was saying, that if a delivery upon cancellation is deciding this right of mine. Plaintiff state Vualka deceived the plaintiffs by taking hold of VMPL company along with his assets, that is the plot and building constructed thereon, with the value of rupees 40 crores at the relevant time, caused by getting the plaintiff 26900 shares transferred in the individual name of the defendant number 2 and further issuing unallotted shares of 445830 shares on a single day and getting the shares transferred in the name of 28 different. Sorry, Miller.
This is the cause of action?
Yes.
Yes.
This third suit was filed next 4 months with him. Allotted shares and getting the shares transferred in the 28 different companies, which were actually controlled by the defendant number 2 behind the corporate veil. It should be veil, Miller. It's the name and details of the companies and the shares annexed are shown in Annexure A to this plaint.
Right.
Your plaintiff state that during the transfer of the shares in the name of the plaintiff 2690 shares, the defendant paid only a sum of 20 per share, totaling to such and such.
Again, para 24, same.
Yes, Willard. The plaintiff's further the shares only an amount of cents per share. Furthermore, Vualka
can't say anything. Can't say anything. Continue. This time you can't say anything. He rebuked his clerk when he came. I said, this time you can't say anything. Continue. Yes.
Further, Mr. Vualka getting transferred the entire shares in his own name or his associates, definitely some ulterior intentions or motive, became the real owner of VMPL and all 28 companies as stated above, whose names and the shares of VMPL got transferred, actually being controlled by the defendant behind the corporate veil. The plaintiff consistently pursued for payment, which has already become due. Mr. Vualka avoided on some pretext or that I mentioned here that every time gave verbal assurances that he would immediately release the due payment of 9.60 crores at the earliest as per the agreement of 16th May and 3 crores as per the second agreement dated 10th April, but yielded no fruitful result.
Yes.
The plaintiff state that till date, since the agreement entered on 16 May 2012 and the subsequent agreement of 10th April 2013, and after complying with the terms and conditions of both the agreements from the end of the plaintiff, and in spite of transfer of 26,900 shares of BMPL standing in the name of the plaintiff in favor of the defendant number 2. Sorry.
Para 32, probably they waive this, abandon this in a sense. And we are putting whatever questions are there so that you can prepare yourself, obviously. The plaintiff state that considering the relationship, the plaintiffs agreed to accept payment of principal amount. So they were aware of the deception, plead the deception. Still, they say that considering the relationship, they agreed to accept the payment. So thereby giving a go by to that fraud apparent. So we'll also have to consider in the light of abandonment of relief as in order to rule. We'll also consider that. The more Mr. Dutt reads the plaint, the more you become nervous. Yes. Yes.
Your plaintiff state as the details, Millard. Then Millard, I come, Millard.
Yes, yes. The rest is regarding transfer of shares and all.
Yeah.
We are only seeking to establish an identity between the two suits. The causes of
they are
for the present.
Yes. For
And also in the process, you have also placed the relevant paragraphs relating to the this agreement, the relief sought, ultimately leading to it's a veiled relief, ultimately leading to that immovable property.
Absolutely.
So that's what you argue. So territoriality also. It was not considered by the learned single.
Not at all.
Yes. Very.
Then Millard, kindly see paragraph 37. May I just have a sip of water?
Yes, please, please, Mr. So Mitru, if after the plaint, if you want to have a glass of water also, you can.
Yes, after reading both the plaints, 3 plaints.
After that, no, first their suit we are not interested. After reading your plaint, if you want, you can also have a glass of water and this.
As Millard has been recorded at page 196, low leave was prayed for, nothing was obtained.
Yes.
And Millard, the suit is for money, decree and interest, leave under order 2, attachment of property of the defendant number 3, which is Salt Lake, and such further and other. Now, Millard, this suit.
পাতাগুলো সেদিনও তো একবারে বলছিল Yeah, Mr. Dutt, in para 22 at page 192, they also say that the names and details of the companies and the shares transferred are shown. So all these companies 2 to 32 here, 5 to 32 in the present suit, they were those companies must have been.
তাই তো আমি কিন্তু এখানে পাইনি লিস্টটা those companies যদি বলো আমি
That annexure is not there.
That annexure is not there. That's why I will before saying it, let me wish. Hey, annexure এ দাও না
Paperwork বানিয়েছো
আরে নেই
So there's a point. Here's a point.
ফাইল করে দিবি annexure I will not say yes until I say it. But Millard,
so this is all regarding the previous one.
Yes. Now we'll have to see, Millard, whether the present suit before the Calcutta High Court is any different, number one, whether if it is not Millard, and if it also tantamount, then Millard, with respect, it must go there. Millard, kindly see paragraphs. Gives me a moment, Millard.
Yes.
Paragraph 34. May I start with 34, Millard?
We'll just come back and start it, sir.
Yes.
We'll take that break and come back. This will be page.
I beg you. This would be the plaint, Millard, in
the page number in the second suit. Second suit, the current suit.
Current suit is Millard, volume 1, page 4.
Oh yes, yes. You started with that. Right. We'll come back and continue.
Could be.
Yes, release.
No, dismiss for default.
What?
Item 50.
Item 50.
File a proper application.
Lord, if I file an application, Lordship may dismiss it. my lord.
No.
Yes. That's why we are asking to file an application. Let us make it formal. File an
The other
No.
side, I'll take consent and come.
No.
No.
Grateful. Fast and open code. File a one-page application.
Yes.
Registration applications, you know how you are.
No, grateful.
If some ground, apart from engaged in other code.
We have to be inventive.
You'll treat me with a cup of coffee.
Yes.
So that you said it's almost a copy paste of the.
Yes, my lord. High Court suit.
The High Court.
Kindly, my lord, see till my lord paragraph 30.
Yes, we can start with the differences. Oh, acha, that.
My lord, he talks of the two suits, my lord, which are in paragraphs 28, 29.
The deception was in paragraph 22 of the earlier print, started from there. No, here it's. Certain new things have been added. Yes.
All the events, my lord, from starting, my lord, paragraphs 28, 29.
Come up with a second agreement, in fact.
Yes, they come to the second agreement. Then what they did under the second agreement are the same as that in the plaint. Then 5 board meetings, my lord, page 30, directors inducted. They were obliged to honor the commitment. Defaults occurred. Then my lord, transfer of shares at paragraph 28. Identical, my lord.
No, the deception part.
Oh, that deception part you not
See, that was paragraph 22 of the earlier plaint.
Lordship, give me a moment. I'll just.
Yes.
Your plaintiff state that in receipt the by making VMPL allow. That deception কথাটা এখানে আছে কোথায়? দুটো বলেছে এই স্ট্যাটিস্টিক্সে কিছুটা একটু বলেছে না ডিসেপশন কথাটা আছে কি জায়গাটা পাঠিয়েছে বলছি যে অন্য জায়গা থেকে I'll check with it. My junior will check and come back. দেখে নাও ভালো করে ডিসেপশন এর Millard, what they have done is, Millard, paragraph 29, they have at page 32.
Yes.
What they say is plaintiff said the plaintiff entered into the subsequent agreement of 10th April by superseding the previous agreement to the extent set forth herein. This was done only for the purpose of ensuring as would appear from the terms of the agreement time of the defendants, however, did not comply with. It later transferred the defendant was not interested to take benefit of the agreement without adhering to the terms. This deception has been, yes. In the year 2014, the defendant number 1 filed a suit for specific performance. This is my suit without complying with the terms thereof before the Honorable Second Civil Judge Senior Division in Barasat, which was registered at title suit number 192, wherein the defendant number 1 has sought for the following reliefs. Millard, specific performance, Then Milord, perpetual injunction restraining the defendants from transferring, selling, charging, encumbering third-party rights over in respect of the Salt Lake property, DN 20. 10 crores in addition, the plaintiff's claim for specific performance, alter incurring to damages. The plaintiff's aforesaid was served on 2nd December. The defendant number 1 has made diverse false allegations in the aforesaid plaint. Herein are contesting the suit and already filed written statement. The plaintiff to file. The defendant number 2, however, till date have not paid any amount of 50 lakhs. Defendant number 1 and 2 have failed and neglected to pay the balance 3 crores and have become due and payable since July 2013, and also 25 lakhs has fallen due. On the one hand, the defendant number 1 did not comply with the agreement of 16th and 10th by not making payment for consideration in respect of the transfer of shares. On the other hand, assumed control of the defendant number 3. As a last attempt to secure the consideration as set forth in the agreements, 16th May, the plaintiffs instituted money suit number 101 of 2015 before the Honorable Judge at Barashat Court, which was registered as money suit number 101. A copy of the plaint is annexed March 15. Till this paragraph, Milord, everything is part of the previous two suits. Now we'll have to see, Milord, whether the subsequent creates a fresh cause of action to come, or if this cause of action relates to the property and the previous two agreements. If that is so, Milord, it's a suit for that. On the first week of September 2015, the defendant number 1 and 2 have appeared and filed an application for staying further hearing of the money suit. From the tenure of the aforesaid application, it becomes apparent that defendant number 2 are not interested in complying with the terms of the agreement and are otherwise exerting pressure on the plaintiff by claiming 10 crore as damages in the specific performance suit of title suit number 192 of 2014. That's the other suit. The plaintiff state that they no longer wish to extend the contracts any further. So that is their defense in the specific performance suit, that we don't want. The defendants have committed breach of the agreement of 16th May and 10th April. The plaintiffs, while scrutinizing the breaches committed by the defendant number 1 or 2, it has now become clear. So the breach has occurred then, which is the subject matter of the two suits. He says that I understand the breach now. The plaintiffs, while scrutinizing the breaches committed by the 1 and 2, has now become clear that the defendant number 1 and 2 from the very inception has perpetrated fraud on the plaintiffs.
So this you say is clever draft?
Of course. Absolutely.
To ask for specific performance, I have to claim damages for offensive. Yes. Sorry. Yes.
The aforesaid revelation has been possible after taking note of the conduct of the defendant number 1 and 2 in attempt to get the title deeds of the property situated DN 20 sectors or like released from the defendant number 5, which was returned as security and executed the same to fulfill its malafide design. This fact has recently come to the plaintiff's notice. The plaintiff have duly notified the factum of terminating the agreement as aforesaid to the defendant number 1 and 2 and 6 to 37. The plaintiffs have also by an advocate's letter of 15th September 2015 notified the defendants with regard to the aforesaid. We'll pause here for a moment, Willard. If I have filed a suit claiming specific performance in which you have filed a written statement opposing that prayer, a subsequent fact, suppose I take it as a subsequent fact, which is a follow of that agreement, is not a cause of action to give you to file a suit on a separate premise, because you yourself say that the issue whether I am in breach or you are in breach, whether it can be performed, is subject matter of the two suits. That's an admitted position. Now this 15 September 2015 letter is the only document which is a lawyer's letter, which is the basis of this suit. And Milord, your lordship,
Sorry, at that juncture, it was available to them. Breach was available to them, known to them.
absolutely
Even your transfers to other persons were known.
available to them.
So they had options either to seek
Seek-
damages for breach, or to seek specific performance, or to seek a cancellation of the agreement. They
Yes.
chose one,
Not-
abandoning the others.
Absolutely.
Now
So,
they resign from that position and they seek to invoke the other.
Milord, this Milord trying to come out of that position and say is an option available to them also
At that
at that point of time.
yes.
Now, this 15 September 2015 letter, Milord,
14th, yes.
is at page 243. All I wanted to show to your lordship, Milord, is this.
Yes.
That whatever has been alleged over here,
The letter is of 15th September. It's pleaded 14th September. But
yes,
from
yes.
43,
No, Milord, it will be 15 September. That I have corrected it, Milord.
it's there plain.
Kindly, Milord, see at page 243. Your lordship will find at page after Milord, 249. Your lordship has come to
249.
yes, come to third paragraph.
Yes.
On the one hand, you have chosen not to, however, your commitment, not to on, it should be honored. Your commitment under the aforesaid. On the other hand, filed a suit on second such and such at Barasat. The aforesaid suit was obviously filed to deny our clients its right and to defraud them. By your acts and conduct, you have stalled realizing the concern of such and such. Aforesaid agreement seeking stay of the money suit, then subsequent events of
But
fraud.
even their first suit was after your after the filing of a first suit.
My
After
suit
that
was first.
alleged attempt to defraud.
Yes. And Milord, the letter, Milord, also shows what he wants. Milord, kindly come to paragraph, page 250, last paragraph. As such, as well, all such
facts.
all have come to light from your recent conduct. Our client has been able to ascertain that you are attempting to get the title deeds of the suit property at such and such released from Allahabad Bank and encumber and dispose of the same during a fraudulent design. In the premises above, our client no longer wishing to extend the contract any further and has determined the same which has already been informed to you. Till date, there is no determination letter. And the plain says that it was informed that it will be resigned. The language is that it was informed that we don't want to perform. There is no termination of this contract till date. But that would be, Milord, on merits.
Yes. But the money suit, their money suit would be shorn of cause of action if there was no refusal on your part.
If there was
no refusal to perform the agreement, because they sought virtually for specific performance.
I
Their
sought
cause of
specific
action
performance.
must have included your implied refusal too.
Yes.
So, which is also a part of the cause of action here.
Yes. And that what I'm trying to show, Milord, is that if your lordship takes my suit, their refusal, their money claim, nothing more, no cause of action has subsequently arisen for them to come before this court and say that part of the cause of action here. So
your attempts to get the title deeds released is only a continuation of your refusal.
that. And that attempt, Milord, is in respect of a property which is at Salt Lake.
That they have
and the police complaint alleging fraud is also at Salt Lake, which I have shown.
Yes.
So, Milord, this advocate's letter, Milord, with respect, will not give him a cause of action to file a fresh suit. And, Milord, such letter, the defendant having unallotted, kindly see, Milord, the defendant number 1 and 2 by having unallotted shares of the defendant number 3 issued in favor of 6 to 33, which is also there in the second suit, have gained control over the defendant number 3. The defendant number 1 and 2 are exercising control over the defendant number 3 through the defendant number 34 who are henchmen of the defendant number 2. The allotment was made in a single day without any consideration thereof. The same allegation there. The issuance is without cannot be survive independent of compliance of reciprocal obligations. In any event, the transfer and allotment of shares, defendant number 3 is ancillary act and co-terminates the determination of the agreement of 16 May and 10th April. Then, my lord, acts of fraud. Your lordship will
just say this at page para 40. If it's coterminous with that agreement and was an ancillary act, so that also relates this to the earlier conversation.
So, as I told you, lordship,
Ancillary, then it's ancillary to something.
correct. My lord, thereafter, my lord, your lordship will find the acts of fraud relate all to, my lord, situations which are subject matter of challenge in the two suits. All of them. Then 42. After coming to know of the fraud, the plaintiffs have already lodged an FIR with the officers in charge Salt Lake Police Station Salt Lake as against the defendant number 1 and 2 on 22nd April 2015. Is annexed here to mark with that the same is lodged outside the jurisdiction of this honorable court. So according to them, the offence has been committed there. Defendant 532 are shell companies. I am not troubling your lordship with that. Defendant number 1 and 2, defendant number 3 usurp the management and control of the defendant number 3. So, court has been called upon to decide the issue of management control of defendant number 3, and thereafter read this, my lord, with paragraph 47. Defendant number 1 and 2 in connivance are invading and are threatening to invade the plaintiff's right to enjoyment of its rights in the defendant number 3, and or is attempting to jeopardize the interest of the plaintiff's interest, thereby purporting to encumber the only asset of the defendant number 3, which is the hospital.
Yes.
So, my lord, a proper reading, my lord, and thereafter, my lord, kindly come to the cause of action paragraph. Rest are, my lord, his averments regarding fraud and all. Cause of action for the instant suit has commenced. My lord, does your lordship copy have a handwritten firstly on 22nd April?
Which para?
My lord, page para 58.
Yes. Yes.
My lord, then it is firstly on 22nd April 2015. 22nd April 2015, my lord, is the police complaint at paragraph 42. Against the defendant number 1 on 22nd April. So, my lord, his cause of action on his own admission, my lord, is an act of whatever criminal nature which has taken place beyond the jurisdiction. So, my lord, every inch of the plaint in my respectful submission, my lord, talks of, my lord, two things. One, a cause of action which was available to you at the time of filing of your suit. The only fact, the only fact which according to you is the cause of action is this 22nd April. This 22nd April also, my lord, relates to, my lord, an offence which has committed outside jurisdiction, because that's why Salt Lake Police has been involved. So no part of the cause of action, my lord, what we do, my lord, is when we plead part of cause of action and the court grants us leave, my lord, court is not in a position to examine that leave. At that stage, my lord, the court grants it, assuming the plaint to be true and correct, till the defendant comes and says that nothing is good. So, my lord, by that way, he gets to get the plaint and move it for an injunction. Now, the court at that stage also, my lord, does not consider anything as towards the merits. It only sees if it has been pleaded.
Yes.
Now, in my respectful submission, if the defendant's declaration that I am denying his right, title and interest in over the defendant number 3 who is holding the asset, my lord, then it is a declaration of my right, title, and interest, if any, in a property held at Salt Lake.
Yes.
So that would squarely make it a suit for land. And my lord, if it is a suit for land, my lord, then there is no question of any part of cause of action arising within. Because the leave can be obtained if it is not a suit for land. If it is a suit, my lord, it's too well established, my lord. So, my lord, this thing, my lord, we took this point squarely in Order 7/11, but this was not decided by the learned single judge. Number one. Number two, my lord, apropos, my lord, what is troubling your lordship, my lord, is that every cause of action you plead in this plane goes back to those two agreements and that was available to you. That was exactly my case under Order 2 Rule 2, pleaded, my lord, in paragraph 10 and 11 of my Order 7/11. So, my lord, this plaint needs to be rejected or returned to be filed before the appropriate forum.
If Order 2 Rule 2 also comes in, then it has to be rejected.
It has to be rejected. Order 7 Rule 11, my lord, if on territorial jurisdiction, my lord, what courts
If
generally
only that you can mold the relief also.
yeah, and return and send it back. So, my lord, this would be on facts. Now, my lord, authorities.
That's it.
My lord, can I give the authorities by way of a note?
Yes.
Because I had only 2 or 3 authorities to cite
Have
that.
the references now. The
Lord,
citations.
Ache. I think
Give the
I
references so that we
I think I can. কোথায় কম্পাইলেশনটা কোথায়? Oh, Lord, 19 judgments by juniors are found. I'll take 2.
We'll pick and choose the best ones.
I'll. এইটা দেখো। কোনটা দেখাচ্ছ?
19টা. And reduce it by 1/19th.
No, suit for land or 2 judgments. Because if it's a suit
for land, yes, you cite judgments. Have you anything similar to this? I mean, where an agreement has been challenged, but in the garb of that land?
Even not only in the garb of this,
I have anything, any judgment with similar facts, then you can cite that would be more appropriate. Suit for land, definitely.
We have that 83 Calcutta 420 that Chaitanya Mott where the purpose of the
cite 1 or 2 years.
I could have been last week. Follow 83 Calcutta bar code.
Or if you can conclude your arguments, if you give your citations,
I have
to Mr. Mitra in advance.
I have concluded my argument.
We'll hear him, Mr. Mitra, today.
Yes.
And you can, whatever.
Only thing is, Milord, if he cites authorities, I have to deal with it. Would become a piecemeal affair. That's the reason, Milord. I was ready with the facts, and your lordship was patient enough, Milord, to bear with me. So, but judgments, Milord.
We will keep it on the next day.
Yes, Milord.
So, Mr. can also come prepared.
Yes.
Next Wednesday.
Next Wednesday.
It's parted in this bench.
We're not keeping it as parted because we
other
are
matter.
now high up. It's already assigned to a bench headed by.
Yes, assigned.
That's the way it's assigned. So if we make it parted again,
No,
don't know.
it is assigned. It's assigned.
So we'll record something.
It's assigned to a bench.
Heard learned senior counsel appearing for the appellants. Push up. The matter be listed for further hearing on August 19, 2026. অঙ্কুরটা পাঠারটা মার্কটা শুধু করো আমাদের রেকর্ড করো you just give the 2 or 3 judgments which you want to cite.
Yes, I'll give it.
Him in advance so that he can deal with that also. And Mr. Mitra, if you can, please just in advance intimate Mr. Yes. So he can deal with those in his rejoinder and you can conclude.
I will give.
করবে না পাঠার মার্কটা করবে না কিছু করবে না যে পরের দিন এমনি আসবে কিন্তু একটু উপরের দিকে তো থাকতে হবে পাঠার দিকে উপরে রাখো এটা তলায় চলে যাবে তাও এর উপরে তো অনেক ভুল হয়েছে তাহলে যেটা বললাম সেটাই হবে listed next on such and such date for, under the heading specially fixed matters. Specially fixed matter করে উপরে দিয়ে। It will appear above the other hearing matters on the next day.
Yes, yes. Well, I'm sorry, Millard. I was not actually. I'm sorry, Millard. Your Lordship had
No question you have argued fully.
Millard, don't. Millard, Mr. Gopal Mukherjee will kill me, Millard, if he's.
So I told him 12:30.
He's not
Mr.
here.
No, he's not
just,
here.
I'll just call him.
Mr.
I
Mukherjee
don't
was
know
asking.
if this matter, then the fun will be increased.
Millard, Millard, please don't do that. I'll bring him up.
He told me
Start his matter also, Mr. That.
after 1:15. I said no.
No, you have a compilation of judgments. You can select from the.
Gopal তাকে phone
করে দিচ্ছি, করে দিচ্ছি।
hold school. Hey, 43
You can just অর্ডারটা যা আছে তাই থাকবে। টাইম পাস হচ্ছে।
Millard, the amount of effort he puts in every matter, Millard, if it gets yes, Mukherjee. Because when he was Millard, I'm told Millard, when he was the Advocate General.
We are going to tell you that I had my experience in another bench when he was AG. I mean, entire endeavor is his. His juniors assist him. His chamber does the work. Everything. No assistance of any sort from his client at that point of time.
Yes, not only he had. Sorry, Millard.
Not any assistance from his client
That
when he
is
was
what
AG.
Mr. Anirban Rai was telling me, that he used to get the list of which matters he used to appear because he is at 10 o'clock. And and he used to make his juniors pass on the responsibility, get ready in these matters. And he says, Dada, at 3 o'clock in the night, somebody rings up and says, Ki korcho? What am I supposed to do at 3 o'clock? And I can't even say because he's awake. I said, no, I'm well awake. I'm ready. I'll do this. So, and he's been maintaining this without even prior to that. His level of, and if after getting ready, he gets dismissed, Millard, he gets very upset. And obviously, why not?
No, definitely.
The copy. না আমারটা দাও প্যারাগ্রাফটা দাও ও কম্পাইলেশন দাও দিও আমার
Basically,
মেল করে পাঠাও তোমরা
My full government. 68.
ওই হ্যাঁ ওটাই বলতে যাচ্ছি ওটাই দোষ এই জন্যই তো তোমাকে চাও আর থার্ড কোন পেজ নেই তো না ঠিক আছে এদিকে শুধু একটু
Millard, 83 Calcutta 420 Millard. Millard, this was a dispute regarding taking control or management of a mort, which was Millard somewhere else, not within the jurisdiction of this Honorable Court, and on the basis of part of the cause of action, the suit was sought to be filed over here. An application was taken for revocation of clause 2 leave on the ground that it's a suit for land because it tantamounts to, and that's the primary relief which is couched in a manner. Now, a discussion on this, Millard, your Lordship will find from paragraph 10 onwards. This was the question. The first question that requires consideration whether the suit is one for land or simply for cancellation of the impugned deeds. The question has to be decided on the basis of the averments made in the plaint and the reliefs claimed therein. We have already referred to some of the averments set out in the reliefs claimed by the plaintiff. It is contended by the learned counsel for the plaintiff that although prima facie it may appear to be a suit for land, really it is a suit for cancellation of impugned deeds of appointment. It is submitted by him that in deciding whether suit is a suit for land or for cancellation of deeds of appointment, the court should try to ascertain what is the dominant and primary object of the suit is. If the primary of the suit is to establish title to land or for possession or control of the land, then it would be a suit for land. If on the other hand, the court comes to the conclusion that the primary object is something else, it will not be a suit for land, notwithstanding the fact it may affect title or possession of the land in question. In support of this, Millard, this was cited. Now we considered the primary object. Millard, kindly come to Millard paragraph Millard, maintaining the suit. Yes, paragraph 12 was Millard. May I continue?
Yes, yes.
We are now to consider what the primary of
That's set out there.
Yes, Millard, the reliefs are set out similar in nature of that of ours, Millard, for declaration and cancellation of certain deeds in respect of management of the property.
Control position.
Yes. And control possession and all. And your lordship will find the same reliefs and this has been claimed declaration and consequential things. Apart from C and D, the plaintiffs have prayed for permanent injunction, entirely restraining lordship from in any way interfering with the right functions in connection with the management, control, administration, custody, and possession of the temple, mosques, lands, properties, and assets of the, including such and such. The claims made by the plaintiff in the suit as contained in the above prayers undoubtedly relate to questions of title, possession, control, and management of the lands and building, necessitating an adjudication thereon. And thereafter, Millard, Millard, kindly see paragraph 17 onwards. Millard, 18. In view of the paragraph 18, Millard, in view of our finding that the suit is a suit for land, no part of the cause of action, part of the land or building having been situated within the ordinary original jurisdiction of this court has no jurisdiction to try the suit. We do not think we are called upon to decide whether part of the cause of action has arisen within the jurisdiction. As I said, Millard, if it's a suit for land, then part of cause of action is immaterial.
That we can also place para 14, 15.
Yes, Millard. Thing is, Millard,
15 in our opinion.
In our opinion, the question whether out of several reliefs in the plain, the claim for the grant of a particular relief which does not relate to title to or possession, control or management, land or building or other removable property is the primary object of the suit or not has to be decided by applying the test whether the relief claimed to be the primary object of the suit can be granted to the plaintiffs without the necessity of any adjudication on the question of title to any land or building or other removable property or possession, control or management thereof. If the relief stands the test, the suit will be a suit for land and for other removable property within the meaning of clause 12 of the latest patent. Although grant of relief may indirectly affect land or other property. If, however, applying the test, it is found that such relief cannot be granted without deciding the question of title to or possession, control or management of the land or other removable property, the claim for grant of such relief cannot be primary object of the suit, and in that case, the suit should be a suit for land or other removable property within the meaning of.
But we said that you do not strictly come within this test because this says whether the primary reliefs, the other reliefs which do not pertain to land, can be granted without adjudicating the question of title or the relief which pertains to title. So here, the primary relief, the other reliefs which do not directly pertain to the land, is the relief of cancellation of the deed simpliciter, which was an agreement relating to land. But that agreement, that relief of cancellation of the agreement can be independently adjudicated without deciding anything on the land.
Beloved, the relief is for delivery up and cancellation of an agreement of March and April.
Yes.
My right to the land is created by these agreements. This is the case of the plaintiff that upon transfer of shares, this land and it is his cause of action in the suit that by taking advantage of this mode of transfer, it's a mode of transfer, he has taken over control and management of the asset, which is the hospital at Salt Lake. So therefore, Millard, if your lordship is delivery up, cancelling this agreement, Millard, then your lordship is also cancelling. That cancellation would include cancellation of my right over defendant number 3 and its assets, which is, Millard, the case which is alleged in paragraph 47. So, my lord, it directly would affect. That's the primary relief. And that is really the reason, my lord, the consequential relief is perpetual injunction restraining him from dealing with the property. Here also, my lord, a deed of appointment was challenged. But it so transpired that the deed of appointment of Shemayat gives him a right to do the Sheva Puja in respect of the property in question.
Your case is somewhat beyond the matrix of this suit in a sense.
Not exactly. I just
Because here separate reliefs are claimed, some in respect of land, some not. The test applied by the court was whether the other reliefs not relating to land could be granted
I
independently,
got your lordship's
which can be done here.
point. Mine is primarily
But
whole
you
thing.
say that yes, even if this test does not come in, the other relief also, which purportedly do not pertain to land directly, also actually pertains to land.
Decide.
The entire fact, the dispute is about control of the land.
And that is
The
his case.
agreement centers around the land.
Yes, that is the declaration he sought.
Admittedly, that is the only asset of the
Absolutely. So, my lord, I need not go to the part test, my lord. I will say, my lord, that the declaration and all reliefs, my lord, pertain to that. My lord, I have confirmed, my lord, the parties in that annexure A, my lord.
Yes. So that you got.
Same to? Miliye sure? Yes.
Those two, those 5 to 32 companies.
Yes.
Good. You can take out
I'll
copies and supply later. Yes.
Gotcha. Well, I'll come back with the other.
later.
Deeply obliged. I'm told Mr. Mukherjee.
Number 22.
Yeah,
Correspondence, my lord.
22 to second call. This is the second occasion. This is the second occasion when none appears on the time of at the time of call. So, although the matter is being called on the second time today, Pushab, as a last chance to the appellant to argue the matter, the same is adjourned for the day. Number 23.
My lord, 23, I appear for
the appellant.
respondents, my lord.
Before I show you the paper, let me give a brief background.
Yes.
The there are two appeals. I just give you the brief background. There are two group of family members. There was a award passed by consent of the parties. One, I am representing the group which is known as the Madanlal Jain group, comprising of MLJ group, comprising of 3 brothers, and the father. And now the father is dead. And the other group is the Mr. Nirmalya Dasgupta. He is appearing for the other brother, the eldest brother, SK Jain, Suresh Kumar Jain group. So there were 2 groups. Now
this is the matter which Mr. Dasgupta was opposing.
Yes. This is that. Yes. Now, here, what had happened? There was an award which was passed by consent of the family members, and a arbitrator was also chosen by the family. Some of the elders from the close-knit family, they are chosen. Award was passed on January 3, 2013.
The dispute pertains to what?
Dispute pertains to the, now in course of what has happened, initially when the award was passed by consent, my learned friend, the respondent SK Jain group, they filed an application under section 34 to challenge the award, saying that, and they filed a civil suit before the Alipur court. Thereafter, they filed a section 34, but their ground is the award is not correct. We were unfair means. They challenged the award, and for 1.5 years they objected, and they continued to challenge the award, saying award is void. Now, after 1.5 years, they withdrew the challenge to the award. They withdrew the suit and they withdrew the 34. And then they filed an execution case. Their execution case, they award date is January 3, 2013, and they withdrew the section 34 on 2nd December 2014. And thereafter in 2015, they filed the EC execution case 873, and we filed our EC, which is 144 of 2016. Now, award, when I placed the award
related to what?
Award related to distribution of the family assets, property, businesses. Because it was a joint family, Lordship know the corpus. Now the family members thought that they have to be mutual separation, and consent award still challenged.
Yes.
Now they filed an execution saying that there are certain obligations to be undertaken as per under the award by my side. And
vice versa.
We filed the similar application that you are not discharging your obligation.
Vice versa.
Vice versa. Now the core issue which is now come up has that the family have many businesses property outside the state of West Bengal. One of the property was situated in Jodhpur, Rajasthan. So they filed an application in the execution case before the learned executing court, saying that there is a property in Jodhpur, it needs to be expunged and deleted from the tabular statement, which is part of the EC. So kindly strike off the property, because they said in the meantime the judgment has become NEPC Micon. The order has come from the Honorable Supreme Court that they can now proceed for simultaneous execution. No leave is required. So kindly delete this property from the tabular statement. We would like to execute this before the executing court in Jodhpur. The application, when the application was moved during the COVID period when court hearings were conducted in VC. So our advocate on record was present. So he wanted an adjournment on the ground that he was not properly and duly represented. Though he was there, but he was not in a position to assist the court. And that was during the COVID period when all hearings were compulsory during the virtual mode. That order is dated 21st order.
He did not have the authority.
I'm so sorry. He was told to take an adjournment. He had no authority to proceed with the matter on merit. And on that day, without inviting affidavit by the learned judge, allowed the application, and leave was given to delete the property from the tabular statement.
You are coming up against a recall order.
So there are two orders.
Only that, not the original order.
No, original order also.
No, two appeals, Malad, two appeals from two different orders.
Your presence is noted.
No, হবে না। NCLT তে বসে এখানে
He's just left.
NCLT? Oh. Wallpaper is very...
Millard, I just left. I was there physically before the Lordship. Millard, I just left.
Exactly. Where are you now? Other
Millard, it's on Ma flyover. Millard.
You send your GPS to the court website, please. Track you. Challenging against recall is very limited. So
No,
the main order also.
The first order is 27th April 2021. And the second order, where we applied for recalling.
What is the ground for challenge to the principal order?
The basic ground is
Was it correct?
on the fact, the learned judge, because the advocate who appeared had he was only asked to seek adjournment.
The ground for appeal is that the name of the senior should be included.
No. The core issue is if an award, the question of law is if an award which has reciprocal obligations vis-a-vis the parties, whether
can be segregated or not.
Whether a party who is facing an application for execution that he is in default of complying with his part of the obligation, which has given me a cause of action to apply for execution and claim monetary relief. My claim in my execution case is rupees 857 crores.
The execution cases
remaining, but he cannot take, by violating his part of the obligation under the award which he owes towards me, he cannot take benefit and apply for taking the benefit to which he is entitled to under the award by taking their property and executing elsewhere. Because it is reciprocal obligations. Because
they are not debarred from putting the award into execution. Neither of you are. Both of you can put the award into execution. They have done it.
Both of us
Both
have
of you
done
have
it.
filed section 36.
No, in the, yes, both of us, no, both of us filed
The,
36.
the segregation was vis-a-vis the property. So
Yes.
it's wrong in there.
Property, there was a segregation.
A part of the property lies in Jodhpur.
Yes.
So that portion was segregated and leave was given apparently to go to Jodhpur and take out a that part of the execution.
Matlab
That is the only part, only order.
according to us, because of the element of reciprocity,
So how
this
does
leave should not have been granted by the learned judge.
you ascertain your costs. You are dismissing with costs. There's nothing.
No,
And Milad, they're contesting before the Jodhpur court every day.
And Mr. Does you add one more line? Will reduce the cost and
No,
first-
no.
This is the second round of appeal. Matlab, in the
first round also.
First round, we got an order. We got an order of the. I will show Matlab, those documents. I have to.
Don't show anything. Just show us the infirmity in the order. You have seen the order actually. Seen both the orders.
Well, order does not say anything. That is the difficulty. Order does not speak. Order has not, because the order is so.
Order says sufficiently.
No,
The
order
says
has
that-
not gone into these issues. Lordship
See,
not
council
find.
places an order which records that the application for deleting the Jodhpur property is pending before this court, by reason of which further. Very well. Since it is correct that the decree stroke award involves both properties and the petitioners have accordingly proceeded both at Calcutta, Kolkata as well as Jodhpur, this court deems it fit to allow the application in terms of prayer A lying at Jodhpur. The property lying at Jodhpur shall be deleted from EC and but nothing. First of all, this is not a judgment under the latest patent. Nothing has been, no rights have been decided at all. Only part of the execution case, which also comprises of the Jodhpur property, has been permitted to be deleted. And they are already proceeding in Jodhpur regarding the other portions.
Lordship, kindly allow Mr. Mitra.
Mr. Mitra is leading you?
Yes,
Mr. Mitra.
My lord, only question is, my lord, whether a decree which, my lord, casts reciprocal obligation on the parties, my lord, can be, my lord, partly executed.
What is the bar? Where is the bar? On the ground of the property lying elsewhere. Otherwise,
Wherever
yes,
it
you might have a point.
Wherever it is, my lord, that really does not, my lord, take it out, my lord, of the purview of a, my lord.
Mr. Mitra, just answer this question, please. Can the courts here execute the award insofar as the Jodhpur property is concerned? In any event, even if it was a civil decree, we could have sent a precept or sent whatever to a court in Jodhpur to get it executed.
Yes.
So why not permit them to go there in the first place? And they have already went there. You are contesting there.
No. We have gone there. We are contesting after the order, not before that, my lord.
No, very well. Let us forget that.
Yes.
But they have already gone there. And that portion of the property has to be executed there. There's
Then, my
nothing
lord,
in this.
then, my lord, the law, my lord,
Now
which
we'll include your fee structure also into the costs.
the law which says, my lord, that decree, my lord, having mutual obligation, my lord, have to be executed at the same time. That, my lord, really does not make any sense. That
But
is
this
what
submission does not make any sense with due respect. That there is mutuality in the award, therefore the execution
One
cases cannot
award,
be segregated. Mr.
one
Kumar.
award.
Property is elsewhere, part of the property. Only regarding that portion it has been segregated.
He can
the law also.
He can obtain order against me here also, my lord, if required. That was the prayer, original prayer.
Executed here. Jodhpur property cannot be executed here.
Depends on, my lord, the nature of the prayer made.
Property, it's an immovable property must be. So then prove. Nothing.
May I, my lord?
The court in any event independently also had to do that, even if there was no prayer. The executing court had to send it to a court where the property is situated.
That depends on, my lord, the nature of prayer made, my lord. Today, kindly don't take me amiss, my lord. May I? Now, my lord, it's a fight between, it's a family dispute. If, my lord, in the executing court, my lord, a prayer was made here before this court that you hand over, or the judgment debtor, I say, the judgment debtor will hand over the property, the possession of the property to the award holder.
Yes.
That can be executed here. That order can be passed by the executing court.
that the Jodhpur property be handed over. Yes, but execution, the question arises, Mr. Mitro, since you have not complied with the order. If the award was complied with,
absolutely,
then
that
there
is
would be no question of any execution case.
that is exactly what I am saying, my
But
lord.
this
That
is an
they
execution
cannot
case.
leave, my lord, they without discharging their obligations under the award or under the decree, my lord. They cannot segregate a part and, my lord, get it
No,
executed.
we cannot put them to ransom because they have not implemented their part of the
My
award.
lord, that is, my lord, possibly the
Which law says they cannot?
that is possibly, my lord, the that is why, my lord, the question of simultaneous execution of a mutual obligation arises, my lord.
Very true, simultaneous execution.
Yes.
But there is no unity between the execution regarding that Jodhpur property and the property situated here. Regarding the other property, the rest of they must have something else also than Jodhpur because one prayer has been
Yes,
segregated.
yes.
They have other prayers
Yes.
which are being executed here only,
Yes.
so far as the property is situated here. So part of their prayers still remain.
Now, my lord, can I, if I may ask myself the question, my lord,
Yes.
can I, without discharging my obligation under a decree, my obligation under a decree, can take advantage of the decree and, my lord, get it executed somewhere else?
Mr. Mitra, this would be ministerial if they did not ask for it. The executing court had to send a precept to the other court, or had to send the matter for execution being executed before the court having jurisdiction there, even in a civil court's decree. Right. In fact, that is what we are saying. I mean, the question of fulfillment of the obligations do not come in. Because they don't come in, that's why only the execution cases have been
That's
filed.
true.
If
That
you
is true.
fulfilled your obligations, you did not fulfill your obligation. Apparently, they did not theirs.
Yes.
So that's why execution cases, once execution cases are filed, the stage of complying with the obligations are gone. That stage is over. That chapter is closed. Now you both of you put it into execution. Their execution case partly remains here as insofar as it relates to the property situated here, and will be taken up along with your execution cases. No qualms on that. Nothing in that.
No,
No
kindly,
dismissing.
kindly, my lord. The decision say, my lord, that
We will
part-
not do it in front of you. We are closing arguments. and
a part cannot be, my lord.
segregated.
That is why, my lord.
We have heard you. Anything else you had?
May I, my lord, formally cite those decisions.
Very well, yes.
May I? বইয়ের কপি আছে নাকি না আর বাকি তো নেই 2015 আর আগেরটা 2006 আমার বই দিয়ে কি হবে হ্যাঁ আমি তো বই ছাড়া পুরো আমি দিয়ে হয় না
একটা প্রভিশন আছে সেকশন 47 এর আশপাশে পেয়ে order 21 টা দেখছি if you come to section 46 of the civil procedure code, in fact you are drawing a rough analogy. CPC is not applicable here to arbitration, but still it's precisely that. So upon the application of the decree holder, the court which passed the decree may, whenever it thinks fit, issue a precept to any other court which would be competent to execute such
That is
decree to attach any property.
absolutely but
So
that
precept is there.
that
It
is
would
not,
be a ministerial act if
that
there
is
was an
not,
application.
that is not always required, my lord, in my full submission. Suppose, my lord, I say
Yes.
by making an execution here, application here, I say that you execute a document transferring the
Document,
property.
yes. But the nature of the award was regarding that property, related to that property.
Yes, property. Now, if, my lord, the prayer is made that you execute a deed of conveyance.
So
in
what
my
is your award regarding that property, Jodhpur property? What does the award say?
I am
That
in
property is to
possession.
be handed over.
I have to give him
So it's
the.
physical handing over. Why should you go to hypothesis? Physical handing
May-
over
may
the
I-
property
may I-
can be
may I?
enforced only there.
Kindly once come to the award, my lord.
Yes, yes.
Starts at page 29.
Right.
Oh, it's APOT 124.
As usual onward.
This was taken here paper.
AG এটা এটাই দেখছি এটা উপর উড়ে গেছে উপরে The award starts at page 26.
Page
20, 29.
29.
Page 29.
IAGA 1.
Just a second. Yes, 22. So we'll come to the ordering portion better.
Yes.
Page 97.
No.
Just show us the Jodhpur property part, Mr. Mitra, if you please.
97. 42. 97.
You are which group? Suresh Kumar Jain? No, you are the other group.
I am the other. Well,
Other. So it's Suresh Kumar Jain group's execution we are talking about.
Yes.
The other six.
42.
Yes.
ইন্টারনেট ক্লোজ এখান থেকে ভালো কপি থেকে করা যাচ্ছে
Let kindly come to
ইন্টারনাল
এটা better copy কোথায় আছে?
বেটার কপি IAGA 3 তে আছে IAGA 3
For the time being, we are interested in the Jodhpur part.
Yes, kindly come to my lord page 41, my lord. The allotment to Suresh Jain group, my lord, take place.
Yes.
Kindly come to my lord page
ইন্টারনাল পেজ হবে আপনার 13 ইন্টারনাল পেজ
থেকে পাচ্ছ ইন্টারনাল পেজ
এই IAGA 3 যেখানে কেটে গেছে legible copy এই দেখুন IAGA 3 তে আছে
The award starts from page 97, para 12. In view of the settlement, arbitral tribunal passes the award in terms thereof, which are as follows.
Very well.
So from that, we'll ascertain the Jodhpur property.
Yes, my lord, kindly come to in that
Yes.
event. এইখানে পেজটা বলো kindly come to page 10 এটা একই ব্যাপার
আপনি কোন ক্লাসে দেখেন
It's probably not there in the 10s.
Sorry.
Is it? It'll be later.
100 থেকে এটা আছে
100 my lord
100 জান
হ্যাঁ জানি দেখছি
Mr. Mitra, we've heard of Machimara Karani. Please come to page 164.
164 volume 2 there
164 of this volume. First volume.
we have a first volume up to 140
You don't have the page
I
164 in
think
the first?
Lordship is looking at APOT number is what
An impression,
no,
124. Photocopy of a dead fly is there. Literally.
literally
So this is, we haven't seen such a literal interpretation of Machimara. It's an impression of a dead fly.
well the page number is not telling I don't know why
my lord lordships are
they
looking
didn't
into my
reach
lord.
Page number is not telling is a secondary issue also,
No,
which also you have
but
to
your lordships are looking into my lord
This is GA1 of 2021,
of
APOT 124 of 2021. The first volume.
page
Page
upper volume is up to 140
my lord
Oh, acha. Sorry, it's 104. It's smudged. 104.
voice very true
I didn't notice it
এটা তো অ্যাপ্লিকেবল সাম কোটে ট্রান্সফার করে দিতে হ্যাঁ ট্রান্সফারটা করছে ট্রান্সফার has been transferred by assembly. Property to transfer হচ্ছে property to transfer. Oh, sorry. আমি কোনো একটা পজিশন ছিল আর একটা পজিশন Sorry, sir. What is it? Find out the Jodhpur property for us in them.
Yes, ma'am.
Which page?
Then page 1-3. I mean,
page 162.
it's 100. I think.
Oh, এটা 100. আমি ওখান থেকে 106.
No,
Sorry.
100.
Kindly,
Yes, sir.
kindly come to my lord, page 100. I was reading this as well.
Yes. Jodhpur property.
Yes.
These are Kolkata properties.
No, before, after
Oh,
that,
Rajasthan, Barmar. That?
yes.
Acha.
And then, my lord, kindly turn the page.
Yes.
It is, however, agreed between the parties that the party of the first part will allow LMJ Services Limited to use and occupy immovable property at plot number such and such, Jodhpur, for a period of 4 years from the date of the award at a monthly rental of such and such.
Right.
For the second year, such and such. Fourth year, which property is owned by Veer Prabhu Marketing and allotted to the party of the first part under this award.
So this portion which they have segregated
Yes.
related to this handing over, permitting them to occupy this immovable property. Page 101.
Yes.
So the portion of the execution which has been sent to Jodhpur by the impugned
Execution
order.
ওখানে যোধপুরের প্রেয়ারটা দেখো।
You have to see the prayer also of
Yes, of the Jodhpur.
A which has been allowed.
Yes.
Yes, they have already filed an execution there regarding that property. Now they want to delete the prayer.
Well, kindly come to their application, my lord, which starts at volume 2, my lord, possibly page 198.
Then master cement actually
Where is the prayer A? That has
Page 19. No.
ওটা master সংস্থা
Oh, the master summons here.
Yes,
My lord, kindly come to page 193.
Yes. Yes.
Now,
It has been allowed.
kindly come to their application.
Yes.
My lord, which starts at, my lord, page 198. Kindly come to paragraph 6, page 202. The petitioner honored about August 2015.
Yes. 202.
page number
Honorable August.
202. Paragraph 6, man.
Yes, yes.
The petitioners on or about August 2015 filed execution application being EC number such and such to execute the said award, which is a dim decree under the Arbitration Act for receiving their benefits and entitlement under the said award. In view of the said restraint order being subsisting, the petitioner could not place for the said execution application. Now kindly come to my lord once, page 408.
Yes. Yes.
Well, this is the order, my lord, they are referring to. Kindly come to my lord, the next page, page 409.
Yes.
So and so, the third paragraph. Appearing on
You
behalf
understood from the so and so that it would be either the
petitioner in EC number 144 submits that during the pendency of the proceeding before this court as well as before the honorable division bench, the custodian was restrained from handing over documents. Well, that for this transfer is not required. Handing over documents.
No.
However, the said interim order merges with the final order dated 19th February 2016. Since the petitioner was enjoying an interim protection, the custodian shall not part with the documents till such and such. Now kindly come to the next page, my lord. Kindly come to page 410.
So we will continue on the next day.
Very good.
Although hearing is commenced, the same cannot be concluded due to paucity of time. Full stop. Please the matter on August 19, 2026 under the heading specially fixed matters. What we are doing, Mr. Mitru, because we are now shy of marking matters as parted. We don't know what happened. So therefore, we are putting these which are pseudo parted matters under specially fixed matters heading. Only in another matter we have placed immediately after that or before that, you know.
May I, my lord? In fact, one matter, my lord, your lordship, it may come back to your lordship's mind, my lord, Justice Bhattacharya's mind, that relating to, my lord, the Estate Acquisition Act matter, my lord, Mr. Anindo made submission on 1st of August, my lord.
We absolutely don't remember.
Very well.
Nothing, we remember nothing about that matter. With so many submissions in the meantime. So
he completed his submissions, my lord. It was obviously before a different bench now.
So then it has to go before that bench.
It is appearing in the list today. It was fixed today. That is why, my lord, I was.
So formally we have to pass an. It's marked as parted.
It's in the appellate side. No.
If it's not marked as a parted, we can take it out.
Specially fixed.
We'll take it.
Because with your lordship's leave, may I mention was item 40 minutes?
Yes, what?
If I am an outstation councillor, I would like to come to physically to argue the brief. If your lordship would have it, item 40 minutes.
40, yes.
Yes. So would your lordship have it next week or the week thereafter, minutes?
It's a bit difficult to fix dates actually. That's a difficulty because we are sitting in this combination in original side only on Wednesdays, the first half.
That's right. The impugned order is being relied upon in other proceedings. So therefore, my prejudice that if your lordship could just
you can always appear, Mr. Kumar, you can always appear online. No difficulty. We have no difficulty with that.
That's right, but there's also the urgency in the matter, because it's been relied upon in other proceedings, the impugned order. So if your lordship would just have the week thereafter,
no special fixation. Sorry, Mr. Kumar. No.
I'm so highly obliged, but I'm so grateful.
Grateful to you.